Hi, this is James Vann with Vann Attorneys. We are really thankful that you have joined us today for our webinar. We're going to be talking about the 2020 lien law update, and hopefully you'll learn something today that will help you in your business. We are really thankful for those people who help us put this thing together. Michael PreNotice is part of our team, and he does an amazing job of helping us with technology. I'm really thankful as well for Morgan Dunn, who is sitting in here with me today. She is a third-year law student at Campbell. She's our law clerk, an amazingly smart lady, and just does a great job. So Morgan, thank you for being with us today. And I told her she was a glutton for punishment to want to participate and hear this. So Morgan, we're thankful that you're part of this. So we're going to be talking today about North Carolina Lien Law. And just give you hopefully some updates and something that hopefully will help you. So some of the things we're going to be talking about is what kind of notice is required, what's the timeline that you really need to be thinking about, the contents of a claim of lien, is a lawsuit necessary? Do you have to have that? Once you get a judgment, what do you do? How does that work? And then we're going to be looking at recent North Carolina case law. So hopefully those things will help you, and we'll be looking at that. And again, if you have questions, we would appreciate you to send those to email. You can email us to webinar@vannattorneys.com, or use the go-to meeting control panel and send those. And I promise you, if you've got a question or thought or comment, it'll be helpful to others as well. So to sort of start out, this claim of lien idea, this little chart that we have popped up for you, is where a subcontractor deals with an owner, or a contractor might be dealing with an owner. So you have the owner, and then you have below that, say, the electrical sub, or maybe the general contractor, or plumbing sub, HVAC, whatever, you can sort of draw it out however that looks. But the owner hires, in this case, these subs or the general contractor directly. So I know some of you get hired by whoever owns the property to either y'all do the work or you provide materials to the project. And in that situation, you would have what's called a direct claim of lien, right? You're dealing with the owner. And a lot of times, so I would get you to think about this. People say, I've got a lien claim. Okay, who did you contract with? Did you contract with the owner? Or did you contract with someone other than the owner of the real property? And that really does make a difference. So if you contract with the owner of the real property, that's the best situation you can be in, possible, having to do with a claim of lien. If you contract with someone other than the owner, again, that's going to put somebody in between you and the owner. So this next slide here, so we have the owner, we have the general contractor, and then we have a line of subs, and then maybe a line of suppliers below that. So if you're on that supplier line, right, you're a second tier sub, maybe that in this case. Everybody in between you and the owner could make decisions or make some kind of impact on your claim of lien and on the money flow, right? So that's why we say I'm going to go back, if you are the directly contracting with the owner, that's the best situation you can be in with a lien claim. And I know not all of you fall into that, right? You might be the first tier sub, or you might be a second tier, could be a third tier. That's not a great place for you to be. And in North Carolina, beyond that, you really don't have lien rights anyway on the dirt. You might have an argument for lien rights on the funds, but not the dirt. So there are really a couple of different kinds of liens in North Carolina. You have a claim of lien, which when you have a direct contract or relationship with the owner, or a subcontractor's claim of lien when you contract with someone other than the owner. And you also have a lien on funds. So if you think about a funnel just for a moment, I need to get a diagram of this. I should have done it, but a diagram. You think about a funnel, right? The big end of the funnel is up, right? It's on the top of the picture. And the bottom end of the funnel, the smaller piece, is on the bottom of the picture. And you think about money, right? You poured money into the top of the funnel, and it flows down through the funnel down to the small end. That's sort of how the subcontractor's claim of lien works, right? The owner pours money into the funnel at the top, and it comes down to the GC, and then it comes down to the first tier subcontractor level, and then the second tier sub, and then maybe the third tier. So think about it that way. Think about the money flow in that way. And I hope that helps you. It certainly helps my brain, and maybe because I'm simple-minded, but that's just how I think about it. So in North Carolina, what kind of notice is required? You know, I know a lot of y'all deal in different states, and you've heard people say, well, I've got to have a pre-notice. Well, in North Carolina, there is no such animal. It's called a pre-notice or anything like that. We have two different types of notices that we actually have to have in North Carolina. So I'm going to give you a little bit of a history lesson just for a little bit. And the reason I say that is, I think if you know the history, right, hopefully the rest of it makes sense. So in North Carolina, we are one of the few states that actually has lien law protection in our state constitution. So in our state constitution, there's a provision that says, if you provide materials or labor to improve your property, you have a right to a claim of lien. That's an awesome thing to have in the Constitution. And I'm interesting. That's amazing to me that it's even in the Constitution, but it is, which is really nice. Well, our legislatures and the legislature in North Carolina have said, okay, you have this right, but they've now put in a couple of different things to say, but in order to keep that right or to have full access to that right, you have to do a couple of things. So, and my argument, I think, you know, because I represent mostly suppliers or folks who are working on a project, I think they're limiting that, right? Because it says if you work and improve real property, you have lien rights. But our legislature said, but in order to do that, you got to do these couple of things first. One of those is a notice to the lien agent. And in North Carolina, the notice to the lien agent only helps the title insurance company, right? That's it. It does not help you at all. Some people would argue, yeah, it does help you, but it doesn't guarantee you that you're gonna get money. It is not a lien. It doesn't give you the protection of a lien, but its only purpose is to give notice to the title insurance company that you're there. Thankfully, this is an electronic notice. You don't have to send the notice by paper, or you don't have to file it at the courthouse or anything like that. You actually do it all from your desk, which is really nice. And I know a lot of you have accounts with the LiensNC group. And again, that's a privately owned group that is 100% funded by the title insurance companies that participate with the LiensNC company that manage this. So it's an online notice. And again, it does not give you any protection of guaranteed payment, right? Under the North Carolina rules, it gives us definitions of who an owner is. It gives us definitions of who a contractor is, first tier, second tier. I'm not going to go through that. Most of y'all know what that is, right? So I'm not going to necessarily go through that. And then also part of that is it gives us definitions of who a lien agent is. It's a title insurance company or title insurance agency designated by the owner. So in North Carolina, in order to be able to get a building permit, the owner or the GC, a lot of times they'll push it to the GC, has to get a lien agent appointed prior to them going to get a building permit. So when you go get a building permit, they ask you who's the lien agent. So you already have to have this, right? So it applies to private projects. It does not apply to public projects. So if it's a public hospital, if it's a public university, a public school, county school, a jail, prison, I'm trying to think of some other, county office building, whatever it may be, it does not apply. But if it's private, they are obligated to get a lien agent if the contract price is $30,000 or more when they pull the building permit, right? There are some exceptions to that not necessarily we're going to necessarily go through, but for example, if the builder is going to use it as his primary residence, then they don't have to have but more than likely they're going to have to get a lien agent anyway. The cost of the improvement, again, is $30,000 at the time to pull the building permit. The appointment is typically for single family residential dwellings. It can be for commercial properties as well. Just because a lien agent is not required doesn't mean there won't be one appointed. So that just sort of gives you a little bit of idea about it. The owner must provide the lien agent information to whoever they are hiring, like say the general contractor. GC is supposed to give it to the first tier sub is supposed to give it to the second tier sub. And we realize that doesn't always happen, right? It sometimes it happens that way, sometimes it doesn't. But that's just sort of gives you the information that how do you get to that, right? So let's look at some search engine tricks. Now this search engine is the search engine on LiensNC, right? So how do you find it, right? How do you get it? And you can go in, and if you haven't already created an account, it's easy to do. If you are a subcontractor, supplier, or labor, we would encourage you to do that, because that protects you so that you can file a lien if you need to, right? So you go in, if you know the number, right? If you've already gotten the number, then you can just put that number in and it'll pop up. Or if it's called an entry number. Or if you don't, you can do it by owner or contractor. But again, you got to think about this. This is the one thing that's sort of interesting about this database. You got to think about what they put in it, right? And that's based off the people that are appointing the lien agent. So if they misspell a word, if you don't misspell it, then, or spell it like they did it, you won't find it. But we're going to give you some pointers. Hopefully it'll help you. So again, if you know the entry number, you can put the entry number in and it'll pull it up. That's something that hopefully would be helpful to you. Also, if you use the advanced search, that's something I do a lot. In fact, that's primarily how I do it. If you know the property address, that's helpful. Try that first. Other legal description, like if you know the subdivision or lot number, or distinctive keywords, like if you put in, like, you know, Jones Construction, you'll probably get a lot. You think of, if you looked at the information having to do with the project, I would encourage you to look for the most obscure word you can find. And we'll talk to you about how do you do that in the search engine. Like if you use terms in quotations, that helps. It'll narrow it down. And that's just, hopefully that helps you. So use some odd words that you think they would be using in that, right? And this is the terms that they've given us, that is the LiensNC folks. You can't use wildcards. You can't just, like you say, the first three letters of a name and it start popping up. You can try the owner, right? Try the last name only. So that, hopefully that helps. They suggest avoid using initials like DR or, you know, D period, R period, or doctor, that kind of stuff. The address, try the road name, avoid street, avenue, drive, because again, if someone abbreviates that, or if they don't put it in at all, it's not going to pop up. Do not use abbreviated or variable words is another suggestion that they have. Keep the search period dates broad, but again, that you might make it broad at first, and if you get too many inquiries or too many responses from that, narrow it down. But again, that's some suggestions that we've learned and some that they've told us. And so I've told you earlier about the advanced search options. I would highly encourage you to use the advanced search portion as much as you can, because quite frankly, I think it's helpful if you don't know the entry number. And I'll tell you another great thing to do is, if they're supposed to post the notice of the lien agent on the job bulletin board. That's by statute, because a lot of us, when this was being negotiated at the legislature, we were having a lot of conversation about, well, where do we put this thing? How do we know about it, right? And so there were some really good folks involved, and they said, you know what, let's require it to be posted on the job bulletin board. And there's a URL code that you can go up to. If you've got one of the scan codes apps on your phone and they're free, you can get them. You can go up, you can actually take a picture of it, and it'll automatically pull up the lien agent on the LiensNC website. So when they print that off, that's automatically on there. So the barcode thing is on there. So all you got to do is take a picture of it. It pops it up. If you've got a salesperson or somebody running by there, they could easily do that, and you can get all of that information right there. You may not be able to go by there, right? We get that. That might not be feasible if this is not a close proximity. And if it's not, that's okay. I mean, there are other ways to try to find it, but that's another way of hopefully helping you to do that. And again, some of the search tips they suggest is search for the most unique word or phrase possible. You know, sometimes, and I hate to say it this way, but I feel like the less I put in, the better off I am, or the less I search for, it sort of helps me figure out, do I need to make that broader now or not? But if you put in too much, you're going to get a huge response back probably. Place multiple words in quotation marks to search for an exact phrase if you think that would work, if that's how they identified it. You can use connecting word and in caps to search for multiple words. So for example, I'm just going to use this, Jefferson in quotations and then another word in quotation, so it'll search those two terms together. So again, we will send this PowerPoint out to you all. You'll get a copy of it. But hopefully this will be helpful to you. So just use that database that way. I'll also say this to you, and we get clients all the time that call us and go, hey, I can't find this job. Can you help me find it? Most of the time we can find it. Not always, but most of the time, 9 times out of 10, we actually can find it. And it's sort of like looking for a needle in a haystack. Sometimes it is, but hopefully that will help you. So we've talked about the LiensNC, right? And we've talked about the notice to the lien agent. And you got to do that to protect yourself so you can file your lien. And the statute says that you have to do that within 15 days of providing materials. Now, I'll tell you, I've had Nick Long is a really good friend, and he is an attorney. He works for LiensNC. And he and I debate this all the time. He says, well, James, that's not really what it means. Well, that's what the statute says, right? So I'm telling you to go by what the statute says, because I don't want a client to get stuck in that. If you've already provided materials, then that's okay. Go ahead and do notice to the lien agent anyway, because what happens is even if you did it late, it's better to do it late than not at all. And you still can do your claim of lien, right? You may limit maybe some of the money that's already been paid out, but at the same time, if you don't do that, then you can't file a lien later. All right, let's switch just a little bit. So there's another notice that you have to have, and it's called a notice of contract and/or notice of subcontract. So in North Carolina, this got implemented a number of years ago by the AGC, Association of General Contractors. And the reason they did this is they said, we don't know who's on the job, right? Subs or suppliers. And they may not know some of the subs that are on there, but most of the time they know the suppliers because they see their huge trucks coming onto the job site, or they see the trucks of other subs or vendors coming on the job site. They know who's there, and they can also ask their subs, but for some reason they chose to not do that. So they came up with this notice of contract. And here's what happened. Here's how it's worded, right? Within 30 days of the building permit being issued or being awarded by the contract, whichever's later, right? The GC is obligated, if they want to take advantage of this law, to post on the property in a visible location and to file with the clerk of court this notice of contract. And it says, hey, look, this contract, this project is under this notice of contract. And if you do this as a GC and the subs or suppliers or second, third tier subs do not send in a notice of subcontract, in essence, you can't file a claim of lien, which it really stinks, right? It goes back to that constitutional argument I've told you about at the very beginning of this. But so there's the real benefit of this notice of contract is to help the general contractors. It has nothing to do with helping you as a subcontractor or a supplier. It only helps the general contractor. And how it helps them is it can cut off any obligation for payment if you've not sent in a notice of subcontract. Now, if you're a first tier sub with a general contractor, you're not obligated to do a notice of subcontract. But if you're second or third tier, in order to preserve your lien rights, you are obligated to send in a notice of subcontract. So hopefully that helps you. So the North Carolina notice of subcontract, if the notice of contract is filed and posted on the job, then a sub or supplier should complete and send in the notice of subcontract. There's no place to file it. You just send it to the GC and to the person you contracted with, right? That helps them to know that you are on the job, right? So hopefully that helps you. So again, there are two really pre-notices that you've got to do. One is notice to the lien agent, that's electronic, and then a notice of subcontract is by paper. And you send that to the GC and to your customer, whoever that may be. And that way they know that you're on the job. So let's look at, say, the timeline at day 60. Like, what should you be thinking day 60? Let's say day 60 is this maybe is your last day of performance or providing materials and labor. What should you be thinking, right? Well, I tell clients, hey, look, day 60, your net terms are probably net 30, I bet, maybe. If you're 60 days out, you need to be having a conversation with your customer. Hey, thankful for the work, look forward to future work, but where's my money on this job, right? Where's my money on this project? You should have an understanding of the heartbeat as to where the payment is and when do you expect to be paid, right? What's that look like? Hopefully they can tell you that. You need to understand where the payment process is. Let me also say this. This is a free one, right? This doesn't cost you anything. So there's a provision that is fairly prevalent in contract law, or excuse me, construction contract law in North Carolina. It says pay if paid or pay when paid, right? So the contract says I'll pay you when I get paid, or I'll pay you if I get paid. Those provisions in North Carolina are unlawful and unenforceable, even if they are in writing, even if you signed the contract, even if you pricked your thumb and put a blood spot on the contract right there, so you make sure you noted it, right? It's unenforceable, doesn't matter. So if your customer says, hey, look, I can't pay you because I haven't been paid, that might be a legitimate reason they haven't paid you yet, but it's not a legal defense. So I said, great, I understand that, and I'm sorry you haven't been paid, but you still need to pay me, right? I'm not being bound by your lack of your cash flow. All right, so day 100, what should you be thinking? Well, I'm thinking I've got to make a decision, and I would encourage you before day 100, you need to be thinking, I got to file a lien if I haven't been paid, because more than likely, the pay apps have already been applied, been submitted. Hopefully, they've been submitted. Money might have already been paid, and you just didn't get paid. You need to be at day 100. I'd say you need to be making your decision because you have 120 days in North Carolina to file your lien from the last day you do work, and you don't want to wait till the last minute, right? So day 100, I would tell you, you need to have already pulled the trigger, or you need to be getting ready to pull the trigger of filing your lien. So hopefully that helps, you know. And a lot of times, another question we get is, how much, what dollar amount should I be thinking about whether it's worthy of a claim of lien? You know, to file a claim of lien in North Carolina, you're probably looking at $1,000-ish, somewhere around there, because we get the information, we verify the owner information that we get from our clients, we fill out the forms that we have, and then you file it, right? And you got to serve it on everybody involved, the owner, GC, and subs. So that's just, I mean, it may be under that, or if the property is really hard to find, it could be a little higher than that, but that's just a general ballpark, right? So I tell most folks, if you've got a lien, if you've got one lien for your customer, and it's, you know, under $2,000 or $3,000, you got to make that call. It doesn't make sense, doesn't sound like it. But if you have multiple liens, obviously, and from the same customer, and say they're all in the same track area, and they're $2,000 or $3,000, depending on what kind of work you're doing each, then yeah, it probably is going to make sense to do that. Because it makes it easier for us if the title work is all right there together, right? It makes it easier to find who the owner is. So that sort of gives you a little bit of a ballpark, and hopefully that helps. So the contents of a claim lien, what's included in that contents, right? It's a lien on claim on real property, right, and or the money. And so if you are a first, second, or third tier, then it's a lien on the property and on the money. You as a lien claimant, that is someone who did work on a project and didn't get paid, you are called what's legally called a claimant. And hopefully you perform some kind of improvements to the real property. So hopefully that helps. That gives you a little bit of background for that, right? The basic requirements for a lien in North Carolina is a person performs labor, provides material, or some kind of professional design. It also includes furnishing rental equipment. There's got to be a contract, and someone's got a contract with the owner. And we've talked about a little bit about who the owner is a little bit. We're going to talk about that some more in some case law that's come up. But somebody's got to agree with the owner to do this work, right? And hopefully that makes sense to y'all. The lien on the real property, you got to have the name and address of the lien claimant. That's you, right? If you haven't been paid, the name and address of the owner of the property, and you got to make sure it's the owner. And a lot of times what you'll find is this: when you first start out, the owner, right, is ABC Real Property Incorporated. Well, ABC may sell the property after you've looked at it, or there may be another group that's getting ready to buy it, and 30, 45 days after you provided materials, it's sold, and you don't even know it's sold because there's no notice or anything like that on the building or on the property. So this is who is the owner when you file the lien. That's what really counts. And a description of the real property. That can be a legal description, can be a street address. The real deal is you're trying to do this. How do I give notice to all the world that I have a lien on this piece of property? Name and address of the person who the lien claimant contracted with. So again, who'd you contract with? First date and last date of improvements, and a general description of what you provided, labor or materials, and the amount due. So a lot of times we get people will call us and go, hey, look, there's a condominium project, right, that's going up. And it's a building, let's say it has 3 floors and there's 3 condos on each floor, right? And let's say that the owner developer has already sold some of those units, pre-sold them, right? Well, you need to know that. And a lot of times what happens, the builder, let's say you're selling furnishing materials, say it's plumbing materials, or you pick it, right? Or you're doing the fire extinguishing for the whole building, right? You got to know, does some of that go into each unit, or is some of that, is it like the hallways? Is it the common areas? You got to be able to know what material went where. So a lot of times we get this, and I mean, obviously, if your customer comes to you and says, I need to buy sheetrock for all of these units, you don't have a clue what's going into particular units, because you don't even know there are units. You just know it's in essence 9 condos. But we really sort of need to know, because every condo might be different in size, maybe. You really need to know in that case what materials went where, and you need to know how much dollar amounts that is. So sometimes that can get really difficult, and I say that to you not to scare you, but just to get you to think about where your materials are going and who you're contracting with, right? And how much is going in. So why are the dates of improvement important? Well, in North Carolina, the dates of improvements are made, they're important because the dates are determined as to when your lien exists. So I'm gonna give you an example. Let's say, for example, that you started providing material of project on, say, January 1 of this year, and you provided materials through the end of March. And say in May, you decide, you know what, I hadn't been paid, something's going on, I need to file my lien. So you file your lien, right, in May. Well, your lien actually relates back to January 1 when you first started providing materials. So your lien on the property relates back to January 1, and it actually would be ahead of anybody that comes on the property after January 1 from a title standpoint, right? So it gives you priority on the title if you have to go that route to get a better secured position of payment based off the real property. So again, that's why the dates matter, and it really is important. One other thing I would highly encourage you to do is this: when you look for dates, your first or last date, make sure that it's the actual date you provide materials or labor. Because I know a lot of times people, and we've had this happen several times, our clients will look at the computer system, right, and they may be going off invoice date. Well, invoice date can be totally different than the actual date you were out there. If your invoice date doesn't match up with the actual date you were working, then that's not going to be accurate. So please make sure that you use accurate dates. That really does help. So, and why are dates important? We talked about that a little bit. It's that gives you priority on the property, right? So we got a question here that came in. If there's no mortgage or lender on the property, or assuming that it's a cash deal, there's no reason for a lien search at closing, and therefore forcing someone to settle your claim by the closing attorney or seller. So I thank you for that question. That's a great question, and it's something that happened to one of our clients recently. So, for example, we filed a lien. Lien was good on the property, right? No big deals. And the property did not have a mortgage. The owner sold it to a new buyer, okay? Sold it to a new buyer, and they did not do a title search. There's no title insurance. It's a cash deal, right? You think about it, I mean, obviously it's not this is not a multi-million-dollar house, but it's a cash deal. So they even say, hey, look, I searched the title, and there's no, that we're not gonna, they say, excuse me, on the title, on the deed itself, it says, we didn't search the title. So you come to find out, you go, wait a minute, how in the world did that close? Because that shouldn't have closed, right? Well, the reason it closed was they didn't search the title. They didn't look for the lien. And because there isn't one there is no lien. In essence, I mean, the lien's there and the lien's on the property. So what happens to your lien? Well, actually, your lien carries over to the new buyer. The buyer really bought it subject to the lien. So in essence, you would, if you were going to file a lawsuit, you would file a lawsuit on the new owner, the previous owner, and the customer, right? So that's happened recently, and that's a great question. So I thank you for bringing that up. But that's how it happened. And so the question is, could they close? Yeah, they closed. The transfer happened, but the new owner bought it subject to the lien. And so sometimes that actually happens, and there is and they actually did search the title, they just missed it, right? And what happens in that case? Well, then the new buyer bought it subject to the lien again, and if they have title insurance the title insurance company has to pay it. And man, I'm gonna tell you, they hate paying a lien claim. But I'll tell you, it's one of the sweetest phone calls you'll ever make. But they hate it. Oh my gosh, they hate it. So again, hopefully that helps on the dates. So what are some traps, things you need to be cautious of with lien claims? Well, and I mentioned earlier, where did you send your materials, right? Do you know where they went? Do you know how much materials went to the project or to the project, right? Let's say, for example, that there's a subdivision going in and you're doing driveways and sidewalks. You're providing concrete, right, for the sidewalks and driveways, and you have one customer that's doing all of the finishing work, and they just say, hey, look, we need X number of yards out here, and you just keep rolling, right? The truck just keeps pouring for this driveway and this walkway. Well, if you don't know that how much went to each lot, then there's no way for you to have a claim of lien if you don't get paid. I mean, it's tough. What happens if it's, say, the curb and gutter for the subdivision? And we've had that happen over a lot of times. Well, in that case, you file a lien on all of it, right? On the whole subdivision. And usually you get paid on that, but it's one of those things, hey, that's just something what you have to do. Can you locate the real property upon which you intended to file your lien? Like, do you know where it is, right? I know that sounds crazy, but a lot of times, this has happened. It's like, you go down West Street, and you turn right on this driveway right past the new condos that they're building, and it's the property behind that. So we think it's 402 West Street. Well, that might be the driveway you pull into, but the actual physical address is something totally different. So we just ask you to figure out early on what that is. When you open up that project in your system, I'm praying that you have project accounts. If you don't, and you don't know what that means, call me and I'll be glad to walk you through it. Make sure, the best time to get the information when everybody's looking at each other and lovey-dovey in the eyes and holding hands and want to make a sweet deal take the time to make sure you know who you're contracting with and where your materials and labor are going. Another thing is the property leased, right? Is it going to be a lease? Is it a leasehold property? Most of the time, most of our clients, I think, know that. But so, for example, let's say I'll take Crabtree Valley Mall, because we filed a bunch of liens out there over the years, not as many lately, but we'll use that, right? And let's just say they're upfitting a space for a new tenant, and you're providing whatever materials you're providing or labor. Can you file a lien on the leasehold property, right, on that space? The answer is yes, you can. There's some people that say, no, you can't do that. Well, yeah, you can. This is the phrase that I learned years ago, and I think it's accurate and it's true. Your lien is only as good as the lease. So think about it this way: you've got the owner of the real property, that's the owner of the shopping mall, right? And then you've got the tenant that is leasing the space from the owner. And then you might have a general contractor, and then first, second, third tier sub. So if you file your lien against the real property, so here's how it works. The owner is going to go to the tenant and go, what are you thinking? There is a lien on this. You need to get, because part of their contract, their lease agreement says you can't have any liens on the leased property. So the GC, or excuse me, the owner of the shopping center is going to come to the tenant and go, if you don't get this lien off right now, you're in default and we're kicking you out. Now, again, they're probably either upgrading or upfitting their space, or it's brand new space, right? So if you're the tenant and you're just going in, or you're upfitting and you're going to spend, say, $600,000 on the upfit, you don't want to lose your lease space over this, right? So the analogy I use is this: if you squeeze hard enough, it's going to squirt out the top more likely. So keep squeezing, because the landlord is squeezing from the top. If we're squeezing from the bottom, more than likely money's coming out somewhere. So that's just my analogy. I would highly encourage you to not give up on that. Now again, your lien is only as good as the lease. If they kick the tenant out, well, there goes your lien, right? But the tenant's not in there. So hopefully that helps. It makes sense. So is the lawsuit required to enforce your lien? Do you actually have to file a lawsuit? The answer is yes, right? You've got to file the lawsuit within 180 days of the last day you do provide materials or labor. So again, the deadline to file your lien, as y'all remember, is 120 days from the last day you do improvements. The deadline to file your lawsuit is 180 days. That's 180 days from the last day you do work. Y'all, it's not work days, it is calendar days. And I will promise you this: we have a program that we use to calculate it, because I can't tell you the numbers of times I've looked at the calendar and we count. You can't do that in your head and always get it right. Now, y'all might get it right most of the time, but not every day, not every month has the same number of days. And you just need to make sure that you get that right, that 120-day deadline right, because if you miss it, you're dead. Don't want to do that. So who is sued in the lawsuit? Well, it's everybody that's involved, right? You got to sue the owner, you sue the GC, and any subcontractor, any parties that's in that chain between you and the owner is who is sued in the lawsuit. So we get this all the time: do I have to sue my customer? They're a good customer, I don't want to sue them, they just haven't been paid. Unfortunately, the answer is yes, you do. And with these terms have been used before. You just say it's a friendly lawsuit. Well, that's tough, right? That's a tough pill to swallow. It's a friendly lawsuit. I don't know many friendly lawsuits. I do know one guy, a friend, who had to sue his mom because his mom rear-ended him driving down the road. That's a whole other story. Won't go into it, but I guess you could argue that's a friendly lawsuit because it's insurance companies fighting each other. But there again, there are not many friendly lawsuits, but you do have to do that. You have to include your customer in that. All right. So once you get the judgment, let's say you sue everybody involved and you get a judgment. Once you squeeze, all the juice out of the real property from the mechanics lien, you obviously would be chasing your customer for the balance. And also say this to you so that you don't forget it. Let's say, for example, that you get talked out of filing your lien. You think, I don't have any good lien rights, it's not worth doing. you just forget, right? Well, whatever happens, you don't file a lien, but you're still owed the money, and you have a contract with whoever you obviously contracted with. There's still that contract obligation for them to pay you, so you can still use that, right? And let me just say this also, I don't think there's a slide that addresses this. In North Carolina, a lien on funds, there is no deadline within which to claim a lien on funds. Let's say, for example, it's you're past your 120 days to actually file a lien on the dirt, right? But let's say you're a second tier sub or a first tier sub, and you realize that the owner still owes the general contractor money. This could be 6 months after you did work, or could be a year. There is no time period addressed in this. But you know that the owner still owes money to the GC, or the GC still owes money to the first tier sub. You can use a claim of lien on funds and still sue those people that say the owner, GC, or GC and sub to enforce that lien on funds. There is no statutory time period that ends that obligation. So just say that to you. Hopefully that helps if you're ever in that situation. So what documentation do you need to have? What documents do you need? How do you document that? Are pictures helpful? Absolutely. So you've got a contract, right? Or you got a purchase order, or you have a subcontractor agreement. Hopefully you have something that talks about what your terms are. So the reason you document it, y'all, it's so helpful to have a contract, right? Even if it's on the back of a napkin or back of an envelope or an email, it's something that tells you what the documents are, what the terms are, how do you go about this, right? And pictures, people say, hey, should I take pictures? Absolutely. They're wonderful. I know some people that when they go in and install stuff, they just take pictures right and left. That's a great, and thankfully today it's so much cheaper than it used to be, right, and easier. Are maps or sketches useful? Absolutely, yep. How about notes? Absolutely. Anything that you do or can create like that is helpful to document what you did, when you did it, how you did it. Because I know now there are times when even in big commercial buildings, people say, well, we don't think such and such is in the walls. Well, actually, we got pictures. We showed this in the walls, right? That's helpful, right? So think about that. The other thing is emails, and we all deal with emails, right? I don't know when it's going to go away, but some people say it's going away, but I don't know how that's going to happen. But anyway, they can be helpful and they can also hurt, right? So if you're not willing for that email to be read out loud in front of your whole company or by the owner of your business, you need to make sure the wording is correct. Or if, as some people say, if your mama read the email out loud to you, would you be embarrassed? Please don't talk trash about the other people, even though that they may be trash worthy of speaking about. Don't fall in that trap. Avoid that. That doesn't take away the obligation to pay you, but it just makes it look silly later if that email surfaces. So think about what you're saying, and that kind of thing. It's really helpful. And I'll tell you, most people now, first thing we go to, I want to see all the emails. I want to see text messaging. And now, get this, y'all, and this is legit. It's going to be interesting how it happens. But let's say you have voice over IP voicemail, right? And it goes to your email. Well, is that included? Absolutely, it is included. So you may not say in an email that person is a jerk, but if you said it in the voicemail and it became an email, well, there you go. Or some, if you just say, look, I know that rascal didn't owe us any money, but we're going to sue him anyway, that's going to show up. I mean, that might be sounds like that's a problem anyway, but you got to think about it. So, sorry, let's look at some case law. This one has been back up a little bit, but I wanted to show it or just talk about it. So the issue was there were multiple lien claimants that were not paid. They were unpaid lien claimants, and that they filed liens. And the court reasons that the lien claims of suppliers and subs exist, if at all, by subrogation to the payment rights of the contractor in privity with the owner. So the takeaway in this case was you need to be early, as quick as you can, to file your lien, because in this case, I really do believe, I really hated this case. We were involved in it. We had a lot of clients lose money on it because the owner, I think the owner and GC were in cahoots, even though it was difficult to prove. the owner fired the GC, and GC didn't pay everybody, and it was a mess. The people who got in earlier to file their liens and got money, but those who came in later didn't get much at all. So here's another one, and we've talked about this one before, but the reason I share this with you is, again, it goes back to something that another case law that's come up recently is, who's the owner? In this case, Blackwell Homes / Blackwell Homes Inc. The contract to purchase, there was an issue about the contract to purchase land and the name on the account with our customer, with the supplier. There was some question about that. Thankfully, the supplier won, but the question really comes down to who was the owner at the time, right? And who did you deal with? Who did you contract with? And this was actually a fight with the bank. And if the bank could knock us out, they stood to make so much more money. Thankfully, even the Court of Appeals agreed with us. And so I just tell you, make sure that you document it. You know who you're dealing with, right? Here's another case, and it has to do with the owner. This was a 2019 case where it came down to what's the definition of an owner, definition of improvement. So in this case, the architect contracted with a potential buyer of the property, right, to do some architectural designs of the property. And the architect had the potential buyer sign a contract. And the potential buyer had signed a contract with the owner of the real property to buy the property. Make sense? Well, the potential buyer never actually went through and closed on the property, so they didn't buy it. Well, the architect filed a lien on the property saying, hey, look, wait a minute, I was dealing with the potential buyer. I've got lien rights on that. And the Court of Appeals said, nope, you don't. Architect's case was dismissed because they didn't contract with an owner. Now, back up 2 slides when I was talking about the other case with the Parks Building Supply. Parks Building Supply, we had that same issue with Blackwell. Blackwell Homes, Inc. had a contract with Parks Building Supply. Blackwell Homes, without the Inc., signed a purchase contract from the owner, right, the developer, to buy the lot. So the bank was trying to say, y'all didn't deal with them, right? You can't have a claim of lien. Well, and actually what happened was Blackwell Homes signed the contract with the developer. It's the same entity as Blackwell Homes Inc. It's the same group, right? Unfortunately, Blackwell Homes filed bankruptcy too, which made it even worse. But Blackwell Homes signed the contract to buy the land and actually bought the land. And it came into Blackwell Homes, Inc. So the bank said, no, you can't do that. Two different entities. One's a sole proprietorship and one's a corporation. And again, had they knocked us out, they'd have made a lot more money. Thankfully, they didn't knock us out. But hopefully that helps make sense to you. It's a little bit confusing, but I'm telling you, you gotta make sure you know who you're dealing with. And again, if you don't deal with the owner, that may not matter sometimes, but just know who you're contracting with as best you can. This next case I thought was really interesting. It's an unpublished opinion, which means that the Court of Appeals issued an opinion on it, but it's not published. So it doesn't mean it means that it doesn't have as much legal precedence, but it's out there for us to consider. So the contract was a $12,000 contract for renovations. The GC was 75% complete, and there was partial work done, and then the owner said stop work. So there was 25% left, right? The GC filed a lien for $12,000. The case said the statute permits liens for debts owing for labor or labor done. And there was an undated certificate of service on the lien. So there's really 2 lessons here. One is they knocked the lien out because the $12,000 wasn't actually owed, because they argued not enough work was done for the $12,000 to be owed. And then the other thing they mentioned was that there's an undated certificate of service of the lien. So people ask us all the time, can I file my own liens? Absolutely, you can. You sure can, not a problem. I will tell you this, there's enough issues in doing your own lien that I would tell you for the dollars that it costs to do a lien, either with us or somebody else, it's not worth it you doing it. We had a client a while back who did their own liens, and it created a bowl of spaghetti mess for them. It was a mess. The GC wound up suing our client for the cost that he supposedly incurred, which he didn't really incur, but for legal fees. And he said, basically it was a title claim on the property, and it was a mess. Well, this case right here, this Coley versus Cowan case, they mentioned it. It wasn't a big deal in the case. Again, it's an unpublished opinion that there was an undated certificate of service. I mean, we could make that mistake, right? But at least we have some documents that would reflect when we actually sent it. So the reason I would tell you this, I would tell you it's not worth filing your own lien, but that's my opinion, right? Here's some other issues that these are not cases that are published yet, but these are things that we've seen in the last year. So for example, there's more lien claims than there is money on the project. So something happens, listen, I'll just use these numbers, make it easy. There's $100,000 owed, but there's $250,000 of claims. How do you do that? Well, what happens in that, right? There's a statute that says if there's more lien claims than there is money, then it's pro rata, it's paid out pro rata. But in order to do that, you have to typically, most of the time, you have to file your lien, you have to file your lawsuit. And that's when they go, okay, everybody who's now done that, we're going to pour the money in the filter and down the funnel, and it's prorated based off of the claims that have actually been filed and perfected. We've seen that more times this year than we've seen in a while. Sort of interesting. Or the owner or GC is bonding off the lien and they don't give any notice to the lien agent. And actually, it's interesting, the statute doesn't say they have to. So if you file your lien, there's a couple of ways they can bond it off. They can hire a bonding company to do it, and then there's like a surety there, sort of like an insurance company, or they post cash at the clerk's office, and then the lien comes off the property. So the money, the cash that's sitting in the clerk's office, or the surety bonding is there for you to go after to get your money. But there's no obligation for them to tell you that. So we've seen that, and it actually just happened the other day. We actually filed a lien, filed a lawsuit because we couldn't get anybody to respond to us, and we were going to send default documents, and we just found out that the property closed. And we're like, how in the world did that happen? I thought it was a case of similar to what we talked about earlier. They just closed over top of the lien. Well, they bonded it off with cash and didn't tell anybody. So now we're applying to the clerk's office to get the money for our client. But we're going to go after them for the balance, right? So the balance being the interest and the attorney's fees and extra costs that we've had to incur. The other issue is the owner of the project files bankruptcy. We've seen that several times lately. So in North Carolina, if anybody in the chain files bankruptcy, you still can file your claim of lien. The question is it going to matter, right? Does it help you? I would say talk to your attorney and walk through that, because it could be helpful to do that. But I'll tell you, the great thing about it is if you do file your lien and it's a good lien, you're secured, right? We have a client who we filed a claim of lien for, filed a lawsuit to perfect the lien. Everything was fine, and we were literally going for summary judgment this past Monday on it, and we found out they filed bankruptcy like last week in Delaware. I'm like, dang gummit. Well, the good news is that our client has a secured lien at that point. They are a secured creditor in the bankruptcy, which means they have a lot higher chances of getting paid in that case. Now, if you are a first, second, or third tier sub, that might make it harder. You're still secured, but it might make it harder to get money if there's not enough money to go around. But I'll tell you, if you don't proceed forward, you're not going to be a secured creditor. You'll be an unsecured creditor. So hopefully that helps. And those are just some issues that we've seen recently. And if you've got questions, we'd love for you to, again, send them to us. You can send it to us by email. or you can use the go-to panel. If you've got that, call me or email us. We'll be glad to do that. And we've got another webinar coming up in September. We're going to be talking about joint check agreements, security and personal guarantees, and how do you optimize those with your customer to make sure hopefully you get paid. Hopefully that makes sense. We really do. We want to provide topics for y'all that are helpful. If you know of topics that we haven't covered and you want us to cover, or if we've covered them previously and you've got a question, let us know. We'd love to. Just tell me so we can try to include that. I had a couple of other questions that I want to make sure that we go over. One was when does North Carolina adopt a standard release form for release of liens, right? Because they're talking about every invoice they're getting wants a new release form signed, and they're all different, right? Well, we've talked about that in the construction setting areas with the banks, lenders, suppliers, AGC, title insurance company. That would be helpful. Unfortunately, there's so many players into it. I have no idea. That's not even on the radar that I know of before the legislature. That's really where it's going to have to come down. It would be so helpful if we did have that, but unfortunately, I can't. I wish I could tell you when that's going to happen. And there's another question that we've gotten earlier that said there, when will we? How do we do job informations, right? Is there a checklist? We will create a checklist for you and send this out to you by email, so you'll have that as to what needs to be done. Like, how do you get the job information? When do you contact your lawyer? What do you do? What's the time frame of that? We'll send that out to you by email. And is there like a pre-made form? So we've got some of that, like the job information stuff. We will send that out to you by email. It'll be the first of the week when you get that probably, but we'll send that to you. Most importantly, we really hope this is helpful to you. That's why we do these. And if you've got ideas or suggestions, we really would love to hear from you. Thank you so much, and we wish you all the best and happy July 4th to you.